Sorry about that. I'll start with the plaintiff. Ma'am, do you have any announcement to make after having an opportunity to discuss this with Mr. Williams?
Yes, sir. He did inform me that he needs to the end of March to be able to pay up the car. I think he sold his his house, and he's waiting for the funds. So if I told him I have no problems with that, but I have to confirm it with the owner who's outside my witness, and if you don't mind.
Okay, so I'll let you go outside and have the conversation with the owner, and if he's amenable, Miss Mary, can we just continue this case for 30 days?
Yes, yeah. For me, I don't mind. But let me just let him know if you don't mind, please.
Oh, okay. I understand that there's an announcement. You can go, ma'am, and go have that conversation. I understand there's an announcement from Mr. Todd and Mr. Joyner. Mr. Williams, would you just have a seat back in the audience?
Judge, I've discussed the matter with my client. They're agreeable to the continuance to have the case continued.
Okay. Will 2 weeks be enough time? It's my understanding the officer was in training
Today, Your Honor. Yes, sir.
Okay.
No, Your Honor, that is the email that I got from the officer. That I can't verify it. I can't.
I understand. The officer is, let's see. Is Officer Mustafa with the Clayton County Police Department. Is that correct?
Yes, Your Honor.
Okay.
Judge, depending upon when the court's going to continue, I just let the court know I have a jury trial calendar on March the 7th and the 14th. I'm on a calendar. I don't know if I'll get called. I just let the court know. I'm not sure. 2 weeks would be fine. I'm just letting the court know, obviously, ahead of time that there may be a potential conflict on my court calendar. But other than that, again, like I say, it would be a court calendar, so I'm not sure whether I get called or not.
Okay.
If we're in agreement on 2 weeks, Judge, that would be February 28th.
Okay.
Otherwise, we are looking at 7th or 14th, which would be in conflict with Mr. Todd.
Okay, let's continue this case to the 28th.
That's fine, Judge. And Mr. Joyner can contact the police officer, make sure that he's available on that date.
I will do as soon as he's in training today, but I'll do it immediately this week.
No.
And I would suggest, I'm glad that 2 lawyers are involved in this case. Mr. Joyner and Mr. Todd, I would suggest the 2 of you talk about a way that this case can get resolved without it going through this process.
Yes, Your Honor, we will.
Okay, thank you. The 2 of you may be excused and your
Actually,
client. I'm sorry.
I'm sorry, before they get dismissed, Mr. Vernon Fowler is wanted in Superior Court. Does he realize he has a court date up there?
He's in what? I'm not sure.
He has hold on, let me read the message from Judge Malone real quick. Give me one.
I think Attorney Joe Todd is supposed to be up in Judge Malone's.
That's me. I have a trial.
I would make your way up there right now.
You may be excused.
And Your Honor, May I just ask for a future reference? Because this is the second time though, like my motions doesn't seem to be making it. Like, how would
Send
your
them to
honor?
me.
Well, I emailed them to everybody as well, but maybe it bounced back, but I will double check that. That's why I came up and physically filed it as well, just to make sure. I just don't want, I want to make sure, you know, I'm on the up and up whenever this stuff happens, Judge. So I'll do that.
No, if you would send it to, like Miss Mary is my judicial assistant. So if it gets into her hands and I'm on the calendar, she places it in my hands. And I know that changes from
So
week
what
to
I
week.
can do is, Mr. Joyner, if you can, send it to me today, then I'll look and see who's the judge on that calendar and make sure it gets in that judicial assistant's hands. And I'm gonna attach it with the file.
Oh, yes, yeah. Well, I mean, it was, the motion was for a continuous today, so it shouldn't be
Okay.
necessary. I just
Okay.
want to make sure for future reference because, Your Honor, when I had a prelim with you and I also had a pre-issuance up here last month, if you remember, I was doing the Shanika Henry murder prelim.
Yes, sir.
When I got here, they didn't have my conflict and everybody was asking me why I was late. And I just want to make sure that I get everything where it needs to be. And that's when I personally file it. And so I figured, you know, when I come up here and personally file it, I would be fine, but I just want to.
No, Mr. Todd, we're still, as they would say, building the plane while we're flying it.
I understand.
A lot of times the information doesn't get sent to where it should go. On the 28th, it's going to be Judge Case Johnson.
Okay.
That's going to be presiding over that hearing. If you send it to Mr. Hutchinson, Maurice Hutchinson, he will make certain that it gets to where it needs to go.
First and last name, phone number. Your Honor, I'm going to get his contact information, his email address.
Okay.
Thank you, Honor. I just was looking for future reference. I just, you know, it doesn't, I don't like the looks of sometimes that we didn't file what we needed to file. And so that's why I was double checking, but I will get all the emails together and just start group sending those as well.
Okay.
Thank you, Honor. When I get through with this, may I be excused with my client?
Yes, sir. Yes,
Thank
sir.
you. You have a good day.
You too. So Ms. Gard, pronounce your name for me so I can stop butchering it.
May Garzidan.
Garzidan. Okay.
Yes.
What did your boss say?
He said that's fine. I mean, we've known Mr. Williams for years, over like 10 years, and this is not our first time dealing with him. And he has no problem working with him. If he needs 30 days, that's fine for a continuous for 30 days.
Okay, so Miss Mary, that'll place
Yes.
it out in March.
Yes, sir.
Now,
Okay.
that would either be March 14th or March 21st. Which one you want, Judge?
Let's do March 14th.
He wants the end of the month, Mr. Williams.
Well, that's
We
not
have
30
to-
days.
Right.
That's
we
not
have to,
30 days.
right. It wouldn't be 30 days. So we have to place it on the next calendar. That's the next pre-issuance calendar. And we try not to pack the whole calendar. So March 14th would be the next available day. If you reach a resolution in this case, just contact Mr. Hutchinson and let him
Yes.
know. So you don't have to, either one of you have to come back down.
Yes, sir.
Okay.
Excuse me, Your Honor. Could it please the court, can I get that information again when they have to return?
March 14th at 8:30 in the morning.
Okay, thank you, Your Honor.
Thank you.
So is Mr. Williams, they're both excused?
Yes, sir.
You have a blessed day, and thank you, Judge.
You too, ma'am.
Thank you.
Have a good day.
Okay, it looks like that brings us to position 7, Tessa Drayton versus Kenneth Green.
Okay, both are present. Ms. Drayton? Mr. Green? Thank you so much. You're welcome. You have a seat.
Okay, Mr. Green, do you still remember the warnings I gave at the beginning of this hearing?
Yes.
And Ms. Drayton, you remember those warnings also?
Yes, sir.
Okay, so I'm going to have both of you raise your right hand for me, please. Do you swear affirm any statements you give in this proceeding shall be the truth, the whole truth, so help you God?
I do.
Okay, so Ms. Drayton, it looks like you're seeking to have an arrest warrant for harassing communications from Mr. Green, is that correct?
That is correct.
Okay. I'm going to ask you to tell me what happened. And Mr. Green, you will have the opportunity to ask any questions of Ms. Drayton. And you can ask questions, and you're not required, as I indicated before, to make any statements, okay? All right, Ms. Drayton, try to tell me in as straightforward and simple manner as possible what happened.
Do you want to hear it from the beginning to kind of explain why we're here today, or just in the past few months?
The reason I'm having a hesitation in answering that is that I'm not gonna try to direct which way you want to go. I understand the basic allegations are related to phone and text messages and harassing behavior. So if you can give me a date, time, and the nature of the communication.
Okay, okay, so date and time, I've got quite a few of them. I have some that are from, start off with November 23rd at 3:03 p.m. Basically, he's asking me, you know, how to be civil. I've told him that because he contacts me and he's not civil with me, he's not polite to me. Basically, he does not treat me the way I should be treated. I mean, like a basic human being should be treated. And I've asked him consistently via text messages to please stop harassing me, to leave me alone. And I've got a couple of different things here notated of text messages where this one specifically, where he, you know, says that he has harassed me, basically. So, and I did say in that text message, and that's December 22nd of this past year, at 12:53 p.m. I asked him to stop harassing me. I even told him, I said, I've asked you to stop harassing me. And he said, I've asked you to let me see my child. I've always compromised with him unless there are times where I'm not available to be able to compromise, because I do work. I'm a single parent at this time. And so I work very hard to try to better myself and the situation that I'm in. So I can't always meet his demands. I've also asked him to politely not to put demands on me. I just, you know, if you want to talk to me like a human being, if you want to see your child, you can see your child. If I don't have the ability to have you see her because I'm flying, because I'm a flight attendant, and I don't have anybody that can take her to see him, I tell him it's not a good time right now. However, he's made comments about my family members being part of the Nazi support group, which, just so you know, I am Black, I'm white, I'm Italian, we're Catholic. He's made inappropriate comments about our religious background. He's attacked my family and myself on a lot of different things. Now, I just want it to stop. One way or another, I just want him to leave us alone. If he wants to have a civil conversation, I'm up for that. I'm not up for being berated, trying to being goaded into arguments, because it's just not comfortable. Now, prior to all of this, even getting here today, I am a victim of domestic violence from this gentleman. He has 2 domestic violent arrests from back in 2019. I'm trying to move forward with my life, and he's making it very difficult for me. So
Let me ask you this question. The arrest in 2019, excuse me, were you the alleged victim?
I was the victim, yes.
And did those cases get prosecuted?
They were prosecuted, yes.
And what was the result?
He had 2 DV harassment. He was arrested twice, and it was 2 DV harassments.
When I say that, was he convicted?
Yes, he got a, oh my goodness, it was DV 3rd degree, and I think it was considered a misdemeanor on both accounts.
And what was the punishment?
Well, he did go to jail. He had to do family violence courses. He had been on probation until, my understanding is, December of this year. I'm sorry, 2021.
Okay. So you and Mr. Green have a child together.
Yes, sir.
Have either one of you, has there been arrangements made as it relates to custody and support or any of that kind
Not
of
as
stuff?
of this point.
How old is the child?
She is 2 now.
Were you and Mr. Green in a marriage when the child was conceived?
No, sir.
Have the 2 of you ever been in a formal legal relationship? Marriage?
I would say no to that. No.
Okay.
We lived together for a very short time.
Okay. All right, you may proceed, ma'am.
I'm not sure how to proceed with this. I've not really done this before.
So, it appears that you're saying that there is contact and communication between yourself and Mr. Green, and you acknowledge him as the father of the child, correct?
Yes.
Okay. So, as the acknowledged parent of the child with no agreement or arrangement in place, how do I know the communications were not for the purpose of Mr. Green attempting to see his daughter? And I'll tell you the reason for that question is because the statute is clear that the communication has to have no legitimate purpose. And it sounded like you in your testimony was saying that he's calling you, and it's about wanting to see his daughter. And if there's no plan in place, let's say that if there is a plan that says every third week or every other weekend, he has custody of the child. And so there shouldn't be a reason to communicate with you other than making arrangements for the drop off when he is going to get his child, and making arrangements for the pickup when the session has ended.
Yes, there have not been any arrangements like that made as of this point. Because again, I am the victim of domestic violence, and I fear his involvement with her at all, unless there is some kind of plan put in place anyway. And I have allowed him to see her. He has seen her a few times last year. He was able to meet with her at the park and play with her at the park. And I feel that places that are public, where should something happen, there are a lot of people around, I feel is safe for the child. Because as a mother, I'll do whatever it takes to protect that child. That's my first and foremost job, is to be aware of the surroundings and where my child is located and who is around her. And honestly, that's all I want. But I also want to feel safe myself, because a lot of this harassment stemmed from even before she was born, obviously. So
So Miss Drayton,
yes, sir.
you and Mr. Green chose to have a child together. You have acknowledged him as being the father of that child. And that may have been a bad or poor decision to have the child with Mr. Green, but he is the father of the child. And I'm going to tell you, if there's no agreement in place as it relates to the communications and the contacts, you're just going to be spinning your wheels. And the two of you are going to be in this child's life for a long time, which means the two of you are tied to each other for a long time. So it's better to work these things out now than to keep jumping along through the justice system whenever there is a dispute.
Let me ask you this. She has not been legitimated by Mr. Green. He did sign the birth certificate when he was not supposed to sign the birth certificate. That being said,
Hold on. Can you explain that? When he was not supposed to sign the birth certificate? What does that mean?
understanding from that is, with his DV in place, he was not supposed to be at the birth of the child, which he was, and he was not supposed to sign the birth certificate, but that has always been very unclear. So he did sign the birth certificate, but the child is not legitimated. Excuse me.
Who told him not to sign the birth certificate?
The judge. At least that is my understanding. I'm not 100% certain.
Okay. I don't think that's a lawful order, but see, as a judge, we can say things and it can have the force of effect, but it doesn't mean that it's true and correct what we're saying. So I can tell you right now, don't go to work today. And that is an unlawful order. You have a right to go to work. You have a right to make a living. I,
I understand.
it would appear to me that the judge would have been maybe in a better position to have the two of you to enter into a custody arrangement.
I have recently filed for custody, and I was also told that he has apparently filed for the child as well. So, but that has not, nothing has begun thus far. So right now there's really nothing really set in place at this time.
Okay. And those were filed here in Clayton County?
I filed mine here in Clayton County last year. I'm not sure about Mr. Green, but I do know that I did file here.
Are you a resident of Clayton County?
Yes.
Okay. Mr. Green, let me ask you a question. Have you also filed for custody of the child?
I have,
And where did you file that?
Clayton County.
Okay. And to either one of your knowledge, has this case been assigned to a judge yet?
Judge Malone, from what I've seen on the website. That's all I've seen.
Okay.
Mine is pending, so I really don't know.
When did you file your petition, Mr. Green?
My petition was originally filed December 9th. I filed on Peach Court. It was rejected because she had already filed in June. And so I just, added my files to it for custody. And I also saw on there that she was filing for a name change in the Superior Court. And the same date that she filed for this quote unquote harassment situation.
And Miss Drayton, is it true that you filed in June?
I did. If I remember correctly, I think it was June 8th of 2021, I want to say.
Okay. So there should be a case pending.
Yes, there is. There's two cases pending. The custody case is pending. And I need to check with the superior courts to see if she's been served or not. But actually,
Judge, there's two cases. There's a name change and then there's a custody pending in Judge Malone's courtroom.
Okay. So you have the right to respond to any pleadings, Mr. Green, and that would be in Judge Malone's courtroom, and it'll appear to be under the case number that Ms. Drayton has, since she has filed first. And there was no order put in place or standing order as it relates to the communication of the parties while this is pending?
no, nothing currently, no.
No, Judge,
Okay. Ms. Drayton, I've cut you off and I've asked you questions. Do you feel as though there's any other things that you need to tell me?
I mean, other than, I don't want anything bad to happen to Mr. Green or anything like that. I just want him to stop with the harassment. That's all I ask. If he wants to talk to me, talk with me civilly. That is all that I require. I don't want him to berate me, especially a lot of times when I'm at work and I tell him, I have texted him back saying, hey, I'm at work. I do not have time to have this conversation. And he'll pop off something really rude back to me. I just don't want to deal with that. It's just, there's more than enough that I already have to deal with. I deal with taking people different places all over the world. I don't need the added stress when I work in a high stress environment as is. So that's all that I want.
Okay, Mr. Green. Before I ask if you have any questions of Ms. Drayton, it seems to be reasonable what she's requesting. Now that there's something filed in Superior Court before Judge Malone, I think this matter probably should be addressed in her courtroom, with everything being handled at one time. And the communications that you have made known to me, Ms. Drayton,
Yes, sir.
it makes it difficult for the court to kind of, as they would say, put the toothpaste back in the tube. Like, two of you have been in a relationship, you have a child, there's reasons to have communications. You're right. You have an absolute right not to be harassed or demeaned or anything of that sort. But it seems like there haven't been any bright lines laid out so that it's easy for the court to make a determination when somebody has stepped over the line. Because if I tell Mr. Drayton, Mr. Green, through a custody situation, have no contact except for this express purpose on these dates. If he goes outside of that, now child could be sick or could be an emergency, and that could be something that the court considers. But if he's calling you just to say hi, and I've said, don't do that, I can place him in jail. I mean, it is because you've said, I don't want communication. You have a child together, so there has to be some communication. But you have a right to not be in a situation where you're getting calls at all times of the day or night. But it seems like that has never been formalized.
I mean, I have told him multiple times, stop harassing me. I don't have time to talk right now. I have made that very clear to him. And it's almost like it's constant, like he'll berate, and it's not every single day or anything like that, but there are times where he'll berate me for a few hours during a certain time or a few days over a certain period of time, and then complete silence. Now, because the child is not legitimized, I feel that I have responsibility to take care of her in the best way that I possibly can, as well as keeping her as safe as possible. Mr. Green has absolutely, not just Mr. Green, but his family has also made comments that the child may not be his, even prior to her birth. They've made inappropriate comments about her color because I am mixed, and that if I were to, have a child that could possibly be darker, that he needs to think about whether the child is his or not. He has even told me that it came from his own family members. And my biggest fear is she comes from a multiracial home. I have cousins that are African. I have other cousins that are very Italian. There's some that are very, very mixed. So I try to show her just love. It doesn't matter what color, what nationality, what religion you are, to love your peers, to love people that are around you, because, that is who we're around,
Miss Drayton, for whatever reason, you and Mr. Green got together on one day and this baby was conceived. Now, again, everything now centers around this child, as far as I'm concerned. And the child has a mother and a father. So you guys broke up. That means whatever you tried didn't work, which means you don't like each other, which means he could be calling you to say hi. And because you don't like him, that feels like harassment. And that's what I'm saying about having a more formalized structure. I know he has no reason to call you on a Monday because child is in your custody. He's not doing anything related to the child. He hasn't received any phone calls about the child is in danger. So if he calls you on a Monday when he's not supposed to call you, that's a clear violation. I can enforce that. But the loosey-goosey arrangement that you have now, I can't come in and start trying to put perimeters on two adults because I'm more concerned about that child than anything else. And so I would like for the two of you to pursue a standard visitation arrangement through Judge Malone's court. And you probably can even get the staff attorney to assist. A more formalized arrangement helps the court to know when communications are appropriate or inappropriate. And like it or not, because the two of you have this child and this child is 2 years old, you're going to be in each other's lives for another 16 years. And that's just how it goes. So today is the time to start formalizing the arrangements as it relates to that child so the two of you can go about your life. And the only time you have to interact with each other is when it's something that's dealing with the child.
So until then, what do I need to do? Do I just need to change my number so that I'm not harassed anymore? What all do I need to do? Because I don't,
Well,
he's not in our lives, I guess is what I'm trying to say, except for when he chooses to be. I feel that in my situation, the only time he contacts me and really cares to talk to our child is when it's pushed by other family members. How's your child doing? What's going on over there? So on and so forth. Now, he's been trying to be more involved recently, but I have handled everything from day one on my own. And so I just don't want, I'm okay with him contacting me. I just don't want him to berate me. And I don't mean.
Miss Drayton, I, as a judge, the only way this situation works is by setting bright lines so that when I hear you say it's okay for him to contact me, but I don't want him to berate me, you have a right not to be berated. But contacting you relating to the child and he gets upset or he says something that you don't like, that does not rise to the level of harassing or intimidating communication. If there is a bright line that says you only talk about picking the child up and he veers into other conversations, bright lines means I understand what was wrong and what was right. So from hearing your testimony today, I don't think the two of you should have any contact unless it's about the child. And Mr. Green, you can take steps with filing motions before Judge Malone, because at this point, the signing of the birth certificate is a step toward acknowledgement that the child is your child. Testimony from Ms. Drayton that the child is your child is a step towards an acknowledgement that you are the father of the child. Now, what happens with that, Ms. Drayton, is that you can't acknowledge that he's the father on one day and then pull it back on another day because he may have said something to you that you don't like and you don't agree with. Because the two of you, and what I think litigants don't realize, the court understands that the reason that I'm here is because these two adults have not been able to work out their problems. So the last thing I'm going to do is try to put it back in your hands to work out problems. So Ms. Drayton has a right to be treated in a respectful manner. Mr. Green has a right to have access to his child. The only way the court can enforce that is through bright lines.
Okay. I guess my final question is, I was under the understanding whether he had signed the birth certificate to acknowledge himself as the father of the child in the state of Georgia was not recognized unless legitimization had happened. So
there's a middle ground. We'll say, and I think the term, if I'm using it correctly, is he's the putative father, which there's evidence that he's the father, but that has not been established. The best way that we know how to do that is through a DNA test.
okay.
Because
he is her father via birth certificate because he signed the birth certificate, but it has yet to be established as to whether he's actually the father of this child.
Mr. Green, did you sign an acknowledgement of paternity?
Yes, I signed the acknowledgement of paternity and I signed a notarized copy of me waiving the DNA test to be on the birth certificate.
So, Ms. Drayton, by signing the acknowledgement of paternity, you have, I think, basically 2 months to withdraw that. So whether he is the father by DNA or not, legally, he's the father. So he can take a DNA test right now and it says you're 100% not the father. He's still going to be responsible for paying child support.
Okay, because he doesn't pay child support. I totally do it on my own. So he doesn't
And
anything really. So
well, that's again something else that should get worked out in Judge Malone's court, because Mr. Green, you should know that if Ms. Drayton says to you, I don't want you to pay for anything, I'll pay for it. And if there's any kind of state funds that are expended for the care of your daughter, the state of Georgia can come after you for those funds, whether Ms. Drayton wants them to or not. And that if she changes her mind 5 years from now and decides that she wants you to pay something, any money that may have been paid from birth to 5 years, you're still responsible for it.
Noted. And I will say there has been a lot of confusion of where and how she wants me involved, because a lot of the text messages are just money, 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 not for the child, but for her and her family. And when I say family, I don't mean my daughter family. I mean her mom and aunt and all that stuff.
And so again, this is why bright lines are
Oh, I agree.
needed and important, so that if Ms. Drayton is contacting you and it's not about the care of the child or picking up the child, then you also have a right to say, I don't want to talk to you unless it's about our child. And so bright lines makes the world go around. You know how to say good fences make great neighbors?
Mm-hmm.
You don't have to say, you stepped over my property line. I saw you standing there. Or your dog came over into my yard. And I see, it just peels the paint off the wall when people try to deal with things in a manner that is not respectful to the other side. Because each of you are adults. Each of you have the right to be treated with respect. And people most often who've been in relationships and they have children, that's the first lesson they learn, is that this person is going to be tied to me. So either I'm going to be fighting and the next 16 years of my life is going to be horrible, or we're going to put some plans in place. And so I know when I can pick up the phone, and I know when I don't have to pick up the phone. Okay. So I'm going to dismiss this application, Ms. Drayton. I don't find that the communication that you're complaining of was made with no legitimate purpose, since the two of you have a daughter together. And I'm not going to jump into that of trying to define a relationship that neither one of you have chosen to define up until this point. You're just two people that live together, had a baby, don't like each other. That's not a good recipe. Okay. Do you have any questions, Ms. Drayton, about steps that you can take?
I guess a protective order. Try that
Well,
again. Because I do fear him. I do want you to understand that I do. I'm very nervous around him. I don't like to be in, like when my daughter goes to meet with him, I always have somebody else that meets with him and my daughter, because I just don't feel comfortable given what I have been through in the past. It's scary.
So you know how the court deals with that, Ms. Drayton? When there's a custody order in place, I can order that the pick up or drop off of the child be done at the nearest police station.
Okay.
And so the two of you can walk into a police station, exchange custody, one walk out while the other stays, gets in their car, drive off. And you know, the next time I'm see that person is at the police station when I'm either picking up the child or dropping the child off. So see, if it's in writing, Mr. Green doesn't even need to call you for the drop off or the pickup. It's already written down, the time. And
does that work with supervision as well? Like if he has supervised visits with her as well?
The court would have to have a reason to say that the supervision or the custody of the child has to be supervised, because he can ask the same thing for you. And we just don't have enough money to go around and trying to get adults to act right. If there's evidence that he has done something to harm the child, the custody can be cut off.
Okay,
But if there are false allegations that he is harming the child, custody can be cut off the other way too.
of course.
Okay.
Yes, sir.
Anything else, ma'am?
No, Your Honor.
Okay. So based upon Ms. Drayton's statement of having some kind of fear, Mr. Green, I'm going to ask you to go sit back in the gallery. And Ms. Drayton, is 10:19 now. You have until 10:30 to get in your car and drive away. Mr. Green, based upon what Ms. Drayton has said, your next communication to her should be through a filing in Judge Malone's court, seeking a custody arrangement. And until you do that, don't contact her. Okay. So the parties can go. Mr. Green, you sit in the gallery. Ms. Drayton, you're free to leave. You have 10 minutes.
Thank you, sir. I
You're
appreciate it.
welcome.
Thank you.
You're welcome. Ms. Kent, I understand that Ms. Kent showed up.
Yes, Your Honor. You want to have her come forward?
You can just let her know her case has been dismissed because she was not here at the call of the calendar.
Hold on a second. She want to say something, Your Honor.
Okay.
Yeah, I didn't know what courtroom to be in. I'm sitting down here at this other courtroom, thinking I was in the right courtroom. Then I talked with the sheriff deputy, and he told me to come to this one. And I told him what type of case it was. I didn't know where I was supposed to be. No one contacted me but a solicitor over the phone.
It says on the notice that was sent out on January 28th,
I didn't,
that it's going to be in courtroom 204.
I didn't get it.
Hold on one second. Miss Mary, this is one of the cases that there was concern about notice.
Yeah, the respondent has not received notice. We're not sure if the respondent received notice or not.
Okay. Miss Kent,
Yes, sir.
give me 1 second. Miss Ken, it says on the application that you live at the same address as the respondent.
The same address. You mean the
Yes,
same,
and I'm not going to say the address because this is
same complex?
over, because it's going over YouTube. So you don't need to have people trying to ride by your house because they saw this.
Oh, no. I don't know if he's the manager of the complex.
Okay.
So I'm not sure if he stays out there or not.
Have you filed a police report about this?
I did everything. I did the police report on the day that it happened.
Your basic allegation is that you're illegally evicted from your home.
Yes, sir. And I was over there. Well, I don't want to get into the case, but
Yeah,
yeah,
don't get into the case. So
yes.
I'm trying to understand, what is the criminal act?
The criminal act was me coming home, finding maintenance men in my house, and my house is empty. That was, and I went to where the head had to sign for everything to go and happen.
So that sounds like a civil action of in a improper eviction where your items may have been lost and you can sue for them to pay you damages. But
it was like caught in an act. People in my house, locks changed.
yeah, but they were, it's not like they broke into your house.
I felt like it because I was violated.
Ma'am, your locks were changed. That's not breaking into somebody's house. That's
Illegal.
someone believing that they have the right to come in, whether they do or not. And they use the key to get in your house.
That's right. You come
So
home.
why aren't you suing the mess out of them to make them pay you for what they did?
I am, but it's the person that did everything ain't even been said about. I came home to maintenance men in my house, cleaning out my house and doing what they want to do, change the locks, cut the lights off. They did what they wanted to do illegally. And I am
Which is why you can sue them. But I can't arrest somebody because they did something that you don't like. I can only arrest someone if they break the law.
I just felt like it was a breaking the law when you go home and somebody in your house.
Ma'am, that's why you can sue them.
That's what I'm doing. But I went from where it started from because it's his job and he knew it was wrong. So I started from the top and maybe I started wrong, but I felt like he was responsible.
So, ma'am, if I hit your car and I cause damage to your car, I don't get arrested for that. But you can sue the mess out of me and have me pay for the damage that I did. So just because, and you may be upset that I hit your car and I damaged your car, but you can't just say, okay, go arrest him because he hit my car and I don't like it. You see what I'm saying?
Understand.
Do you understand the avenues that you have to take in order to make yourself whole?
Yes, sir. I got a lawyer.
Okay. This case is going to remain dismissed. And ma'am, I'm not saying that you don't have an avenue to make yourself whole. I'm just saying, as a judge, I got to follow the law too. Okay? So you're free to go. And you may, while you're here, want to go check over in the, either it's probably online now with the claims, but you can fill out a form in state court. Depending on the damages, it may be in magistrate court. Our jurisdictional limit is $15,000.
Well, it's out of your jurisdiction. Everything in my house is gone.
So as long as you can prove that it happened, you have an incident. I mean, when I say prove that it happened, you have an incident report that you call the police. Police officer gave you this information. you can show your damages, you'll walk out of court with a big smile on your face. Okay?
Yes, sir.
All right, ma'am, you're free to go.
Thank you. Yes, ma'am.
I understand that Chantrell Connor is here.
Yes, yes, sir. You want to speak to her, Your Honor?
Yes,
Make your approach.
yes.
Thank you.
So, Ms. Connor, this case has been dismissed for warrant of prosecution, which basically means when the court calls the calendar, the parties have to make an announcement that they're here. And when I called your case, there was no announcement made, and you're the plaintiff. So, or petitioner, so it was dismissed for warrant of prosecution.
Yes, that is because when I got here, I didn't know what courtroom I was supposed to be in. I went to the clerk downstairs. They said that they couldn't find it. Then I came up here and she told me to check these two, 202 and 204. So there was no one out there and the door there was locked. So I just sat there and waited. Then when I seen someone come in, I came in and he let me know, the sheriff let me know that I was supposed to be in here.
Right. So when you filled out this application, it looks like a notice was sent out on
February the 2nd.
Okay. Looks like it was signed January 28th, but the notice, it says courtroom 204 on it.
Yes, I moved on February the 1st from an apartment complex and my mail wasn't transferred in order for me to receive it, but I seen it inside of my, I have an alert on my phone and I seen the front, but I didn't know what it contained.
Okay. Well, you can attempt to refile, but it's been dismissed for warrant of prosecution. Okay, you're free to leave, ma'am.
Thank you.
All right, position number 8, Jaleel Hutchins versus Woodcliff McKay Jr.
Your Honor, I'm going to go ahead and put Mr. Hutchins in the other room. And Mr.
Okay.
McKee, come forward. Stand by, Your Honor.
Please. Are you Mr. McKay?
Yes, good morning, ma'am.
Okay, good morning.
I know that you have a witness.
Thank you. Good morning, Your Honor.
Good morning. You are Mr. Hutchins?
Yes, I am.
Okay. Mr. McKay, do you remember the rights that I discussed at the beginning of the hearing?
Yes, good morning, sir.
Okay, and Mr. Hutchins, do you remember those rights?
Yes, sir.
Okay. Let's see. You can go ahead and have a seat, Mr. Hutchins.
I'm sitting.
You prefer to stand?
No, I am sitting.
Oh, okay. All right. I'm going to have the two of you to raise your right hand for me, please.
Yes, sir.
You swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God.
Yes, sir.
Okay. You may put him down. Mr. Hutchins, sir, you have the burden of production and persuasion, so you get to go first and tell me why you're seeking an arrest warrant against
Yes, sir.
Mr. McKay.
I also have a witness outside, if I just wanted to add that.
Okay.
It's been like a 3.5 year ordeal. I brought my car to this gentleman to get it fixed. I bought it there to fix a water pump and to get the top spray painted. He charged me approximately $300 for the water pump and like $450 to do the paint job. It took us several months and it was done. Then I asked the gentleman about getting new headlights. And after that, it's just been one leading on, calling him till the pandemic came up, and then I called and the phone was disconnected or something. The phone to the place was disconnected. I inherited osteoarthritis. I couldn't get to him half of the time. And when I got over here a couple of times with my witness driving me, he said it was going to be ready, and it wasn't going to be, and it wasn't ready. This has been going on and on until the last time I just snuck up on him after, well, that's what I call it, after the pandemic died down some. And the guy, I got pictures of, he had big metal things on the back of the car. The back seat was taken out for us to look at, but he left it out so the metal could rot. The front headlights was taken out so the wires could rot. I'm like, the panel inside the car.
Mr. Hutchins, let me stop you 1 second, okay?
Yes, sir.
Because it sounds like you're raising a civil claim that you had an agreement with Mr. McKay that you believe he didn't fulfill the agreement. And because of that, you feel like you have lost value in your vehicle. Is that correct?
I think it's part both, Your Honor, because he kept my vehicle to do things with it and use parts for other cars.
Okay.
And
so hold on, Mr. Hutchins. Yeah. So what crime is that?
Theft.
How so?
Because he kept my vehicle.
Did you ever demand for your vehicle to be returned?
Yes, sir.
And what was his response?
I got you, man. I got you, man. This has been ongoing for 3.5 years until I finally decided to come put the complaint there.
So, Mr. Hutchins, I'm gonna ask you what part of the behavior constituted theft?
When he didn't give me my vehicle back, when he didn't he destroyed my property. I can understand that can go two ways, but that's all.
Did he come and steal your car from your house and place it in his lot, or did you agree to have the car repaired at his lot?
I agreed to have the car repaired, sir.
So, I'm not seeing the criminal act. I see civil liability, but I'm not seeing the criminal act.
When he wouldn't return my car to me, sir, that's not theft?
No. Was the car in a condition where it could be moved?
No, sir. The last time, at first it was, the first year it was when I asked for the headlights. The last time I came back, I demanded to jump it and get my car out of here. It was in no condition for all that. Everything inside was destroyed.
And so the witness that you have is the witness, is a person that was taking you to the location for you to get your car.
Yes, sir. It was like 4 times this witness brought me over there.
Okay, I can accept that without having to hear the witness tell it to me again.
Okay, sir.
Okay. Mr. McKay, do you have possession of Mr. Hutchinson's vehicle?
Yes, sir.
Has Mr. Hutchins requested the return of the vehicle?
The last time he came to my shop, he said, he got so upset. He said, I'm gonna take my car, pull my car out of the parking spot. I jumped the car off with my jump box and I drove the car out of the parking spot for him to take it.
Yeah.
At that time, he said,
Hold on, Mr. Hutchins.
at that time, he said he was gonna call a tow truck to pick up the car. Then he said, I'm gonna leave it, a tow truck is gonna come and pick it up. I drove it back in the parking spot and left it. After that, I received a letter from the court to come to court. The car is
Mr. Hutchins,
Yes, sir.
did Mr. McKay attempt to return the car to you?
Sir, the car would not start. Him talking about driving it is not true about anything. He tried 2 different jumps. And then when I seen inside the car, I said, it's best I leave this car alone because before somebody said I did this, all this damage. The car would not start. That is not true.
So Mr. Hutchins, you asked for your car back, and based upon your testimony, Mr. McKay made 2 attempts to jump the car off, but was not successful. Is
Yes,
that your
sir.
testimony?
Yes, sir.
So how is he holding your car without giving it back to you?
By the time they went to do that, Your Honor, I did get a little loud. I took pictures, but when I seen that the car wouldn't start, it's like, why would I bring this car home when it doesn't even start no more?
So
And
how, again, what's the crime? What is the crime? You asked for your car to be returned. He attempted to return it.
Sure, that was like a year later when we finally went to do that. That he what I'm saying is he couldn't even jump it to return it. When I brought my car to him, my car was movable. My car had a trunk. It wasn't sun damage all through the hood. So yes, I understand that destruction of a vehicle is a lawsuit. But as the officer explained to me, he also stole your property from me. Now, if that's true or not, it's for you to determine.
So what officer said that?
When I went to file a complaint at the precinct,
so why didn't the officer get in his car, drive over to Mr. Hutchinson's or Mr. McKay's location and place him in handcuffs?
I don't know.
Maybe because it wasn't a crime.
But I didn't, that's what they told me to put down. If it's to file a lawsuit against this man, I definitely will. I got pictures of how he destroyed my property. And
so,
so
Mr. Hutchins, let's take what you're saying as being the 100% truth, and that it is a crime. What's the remedy?
The remedy is pay for the damage that you did. Or if he has to get arrested, he has to get arrested. I just wanted to file right too, because this man did this and walks away with just take him. I had to rent cars and Ubers for like 3 years because I could barely get around.
Which you can all file a civil lawsuit and get repaid for that. We don't arrest people for being bad mechanics or bad business people.
I'll settle for that.
So if he had broken into your car and took it, and you got it, the car tracked, and the car was located at his shop, that's a crime.
So if you hold my property for 3 years and don't give it back, that's not a crime?
Not about what I heard today. Sounded like you wanted your car repaired. And when he was saying, I got you, he was, in your opinion, stringing you along. At any point, you could have said, hey, I want my car. I'm bringing a tow truck up here. And if you try to stop it, I'm calling the police.
I wanted my car fixed.
I know you want your car fixed, but if you still think that Mr. McKay is going to fix your car, you may be delusional.
Oh, no. I'm talking about in the beginning, sir.
No, which that's why we have civil laws and criminal laws.
Okay.
So you can touch his wallet and he would be more upset than spending a day in jail.
Yes, sir. Yes, sir.
Okay. All right.
Unless
Unless there's something else that you have that is testimony of a criminal act, I'm gonna find that there's no probable cause to arrest Mr. McKay.
And I'll go downstairs and file for the lawsuit. Yes, sir.
Okay. I'm gonna dismiss this case for lack of probable cause. And Mr. Hutchins, because you're the accused, I'm not gonna ask you to make statements. But based upon what Mr. Hutchinson said, you may be liable to him. And I think you should consider how much. Because, I mean, while the car is in your custody, you have a duty of care. Car doesn't get broken into, car doesn't get damaged, all of that kind of stuff, you can be liable in civil court. There are acts of nature. There are certain things that even if you were God Almighty, you couldn't prevent happening. You're not liable for acts of nature, but you are liable for not giving proper duty of care to a vehicle that you took into your custody. When you make that action, sir, there's a reasonable belief on a person in Mr. Hutchinson's care that, in Mr. Hutchinson's position, that you will do all that's necessary and reasonable to protect his property. And if you're found to not have done that, and the property's in a worse state, you may be financially responsible for that. But that's a matter for another day.
Yes, sir.
Okay. The two of you are excused.
Thank you, sir.
Thank you.
And position 9 with Kimberly Cothran, that was a case that we had to check service on. Miss Mary?
He's coming forward, Your Honor.
Okay.
Correct. No, we didn't get the notice back from the post office, so we don't know if he actually received it or not.
Okay, so Ms. Cochran, what we do is we serve these notices on the accused by certified mail so that we can be reasonably assured that the address, 1, is a valid address, and 2, that the person received notice. In a situation where we don't have an indication that the person can receive notice, we will check the service on it. And if we believe that Mr. Lynn Jr. received service and just decided not to appear, he's perfectly within his rights to do that. but you still get to go forward with your case. So we're gonna put this on, what calendar are we on now, Miss Mary?
Depends how long you want to give the continuance to, Judge. If you want to give it 2 additional weeks, that would be February 28th.
Miss Cothran, do you believe you can return on February 28th?
Yes, sir.
So what we're going to do is we're going to make sure that this is a situation where service went out, and the person is not just unaware. And the reason we do this is because sometimes people will inadvertently put the wrong address down, and we proceed with one side of the story, and we don't find out that the wrong address was there until the person is arrested and brought into custody. So if somebody's going to go to jail, we want to make certain that we did what we were supposed to do for that person to receive proper notice to come to court.
Yes, sir.
So it'll be February 28th at 8:30 in the morning. It'll be Judge Kate Johnson, be the judge presiding over that calendar.
Yes, sir.
Okay, ma'am, you're free to go.
All right. Thank you so much.
You're
All
welcome.
right. 2.
Is that it, Maurice?
Yes, Your Honor.
Okay. Miss Mary, I will call you offline as it relates to, looks like we have 3 continuances. 3 dismissals for warrant of prosecution. And that's positions 5 and 6. And 7 and 8, we had hearings, and they were dismissed for lack of probable cause. Okay.
Okay.
If I haven't missed anything, I will go offline. And like I said, I'll call you, Miss Mary, and we'll see what we got for this afternoon.
Thank you, Maurice.
Oh, you
Thank
welcome.
you.
You